Yes? Good evening and welcome to the Planning Board meeting. Steve, can you hear me?
I can hear you now.
This on green, but it's not working. Let's try this one. Test, test, test. These microphones ain't working.
Steve, can you speak now?
Sure. Can anyone hear me?
Yeah, so I can hear him on my computer, but not on PAC TV.
They're not working.
The mics aren't working either.
Test, test.
Now they're working.
Shut that off.
Are you hearing it? I think he's on.
No, I can hear some of the test.
Steve, can you hear me?
That I could hear.
Okay. All right, let's start from the beginning. Good evening and welcome everyone to the Planning Board meeting for Wednesday, January 24th, 2024, in the 1820 Courtroom, 26 Court Street, Plymouth, Massachusetts. First on our agenda we have, well, first I need to read pursuant to Chapter 2 of the Acts of 2023, an act relative to extending certain COVID-19 measures adopted during the state of emergency, signed into law on March 29th, 2023. This meeting will be conducted via remote in-person participation. Specific information and general guidelines for remote participation by members of the public and or parties with a right and or requirement to attend this meeting could be found on the town's website. First on our agenda this evening, we have administrative notes. I do not see any minutes, but we have a covenant plan of release, B 615 Elbow Pond subdivision, bond reduction. Questions, comments from members? If not, I'll entertain a motion.
If I can turn this on, I'll do a motion to approve.
You got it.
Okay. A motion to approve B615 Elbow Pond subdivision, bond reduction.
Second.
We have a motion and a second. All in favor? Mr. Bolton?
Yes.
Carl?
Yes.
Ms. Keene?
Yes.
And myself, yes. We're going to go a little out of order this evening because one of the people that are making a presentation has to go before the Advisory and Finance Committee this evening. So, with that, we have ZBA 4118-132R Sandwich Street, special permit required per section 206-2G.2 to construct the building within the floodplain overlay district. Good evening, how are you, bud?
Good evening, thank you. For the record, David Gould, Director of Energy and Environment. Thank you for allowing me to appear before you tonight. I think as most folks know, this is relative to the Stevensfield project that's currently underway, and more specifically a concession building that falls within the floodplain overlay district. The plan that you see up on the screen details what we're looking to do. So for those of you who aren't familiar, there was an existing concession building out at Stevensfield. It was approximately 55 feet away from mean high water. That building has been demolished. It was approximately 55 feet from mean high water and at an elevation about 10.6. The new concession building that we're looking to do is 250 feet away from mean high water and at elevation 14.5. So what we've done is try to relocate the concession building both as far away from the edge of the water as we could and also get it up to a 14.5 foot elevation. But it does fall just still within inside the floodplain district. So the request is for a special permit to allow that to occur. The plan that you see shows that proposed location, and there were a couple of points that I thought I would point out in the peer review from environmental partners as well. So they had a question about the availability of alternative locations. We actually proposed to put it in that location for several reasons. We did want to get it as far away as possible, but we still wanted it in somewhat close proximity to the playground structure where smaller, younger children will be playing, and then the parents can walk directly across the roadway to the bathroom facility. If we moved it to other locations, it would be significantly farther away, and I'm not even sure people would realize where the bathroom facilities would be. So we wanted to address that issue. As far as the necessity of the facility at this waterfront location, which was a question that environmental partners raised, certainly we do need bathrooms at this facility. We'll see a lot of use once it's completed. And then the third point that I just wanted to address was the question based on the use that they expect the proposed building will be inhabited periodically and will likely not be operational during inclement weather, and that is absolutely true. There will be a seasonality based on when the concession building and the bathrooms are being used, so that point is also accurate. So with that, I will attempt to answer any questions anyone may have.
Okay. First, I'll go to staff. Anything to add?
Thank you. I just wanted to add that also the project has received the order of conditions from the Conservation Commission back in, I believe, the spring. So they have the order conditions approved, and they also have the license from the state, the Chapter 91 license that was issued originally in 1998 with minor modifications for the site and kind of ongoing work. So those are the two required permits and assurances that they needed to obtain. All the other ones that are listed are not applicable to this project. And as Dave said, they've moved it back to a more a location that is further away from the coast and also still centrally located so that it's accessible to all the different amenities within the park area. And Public Health Department had no comments, adverse comments. The Plymouth Center Steering Committee unanimously supported the project, and environmental partners didn't have any issues. They just had a few questions that Dave has addressed. Thank you.
Thank you very much. First, I'll go to the audience. Is anybody here this evening wishing to speak on this case? Seeing no one. Anybody on Zoom? Lee? Anybody on Zoom wishing to speak?
No. Is there anybody on Zoom that would like to speak to this?
No.
No hands. Nope.
Okay, well, I'll bring it to the board. Carl?
Actually, I didn't even have any questions, so it just seems like it's everything's good within the requirements of zoning, and there's really no anything else to add besides what you already put towards us, correct?
Yeah, our next steps will be obviously going to ZBA and then obviously getting a building permit from the building director of inspectional services, but those will be our next steps once we go through this process. But the rest of the site is under construction and everything's moving along well. And I don't think we're going to have any issues siting the building where we're proposing, so I think we're in good shape.
And just out of my own curiosity and probably the curiosity of some people in the community, when is the timeline, and what are we looking at for a timeline for finishing and starting and things like that?
I think you would be the first of many people to ask me that question going forward. So we're pretty well into construction. We have tennis courts and pickleball courts all poured. We're working on the fencing around both of those. We're working on the perimeter drains around those. We're probably halfway through the subsurface drainage work. So we anticipate obviously quite a bit of work when the weather gets better. But we have an ambitious goal, but we also have an excellent contractor, so that's significant. So we have a goal of trying to open the park July 1st. If we have to push that back, I'll gladly take that criticism to make sure we do as good a job as possible in the park. But at latest, I do think it will be open for at least part of the summer if it's not July 1st.
Okay. So not before the parade, or because we could use some parking because last year was a little
Correct.
atrocious.
Yeah, we'll get that park open. I know folks, when the good weather comes, people are going to want to get out there. So we'll try to get as much of the summer open for folks as possible.
Thank you very much.
You're welcome.
All right, just to clarify, the planning board is not the adjudicatory board. The final decision will be made by the zoning board of appeals. We will send a advisory report to the zoning board of appeals so that everybody knows. We are only advisory to the zoning board of appeals. Ms. Keen?
Thank you. Is this working? It's working? Yeah, good. It's hard to tell. Thank you, David. I've been involved with Stevens Field ever since I walked into this town because it's been going on now, 15 years? So I only have a couple of questions because I wish this project well in all of its iterations. How far exactly are you into the overlay zone?
We're essentially right at the edge of it. So the back of the concrete pad that the building sits on is essentially right at the end of the floodplain district.
So while the Department of Public Health had no concerns, this is town water, town sewer. So if we have one of those astronomical tides during a storm, et cetera, which we're all very familiar with, is there any backup plan? Closing it, I understand, but should the toilets or the water get inundated, how would you address that as being part of the overlay plan?
So I think, again, one of the overall goals of this entire project was to move as much of the infrastructure away from the shoreline, and that not only included the building, but a lot of that infrastructure that just referenced. So the sewer line that went into the facility prior and the one that's going into it now and towards this building have also been relocated back. So everything, including those utilities, have been pulled back. The elevation throughout the entire area where those utilities will be located in the road are also going up in elevation. So I think that's essentially the extent of what we can do to protect those pieces of infrastructure. It will be used, like I said, periodically. It's typically not going to be open during December, January, and February when we get those kind of storms that would inundate the coast. So I think those things also align well.
Okay. That's the end of my questions. Thank you.
Okay, thank you very much. Mr. Bolton, are you there?
I am here. Thank you, Mr. Chair. I have no questions.
Okay. Rosemarie, any questions, comments?
I have no questions or comments, thank you.
Okay. And I do not have any questions or comments other than wish the project good luck, and let's get the thing completed, but let's get it done properly and let the public get some use out of this field and the whole area for sure. So, with no other comments, I'll entertain a motion.
Motion to approve.
We have a motion and a second. Mr. Bolton,
Yes.
Ms. Keen,
Yes.
Mr. Donaldson,
Yes.
and myself, yes. Thank you very much.
Thank you, and thank you very much for taking me out of order. I appreciate it very much. Thank you.
And we get preferential parking there because we let you go first? No? Oh, I tried. All right, next on our agenda this evening, we have a public hearing, which I will read into the record. Notice of public hearing. The planning board will hold a public hearing in the 1820 Courtroom, Town Hall, 26 Court Street, Plymouth, Massachusetts, on Wednesday, January 24th, 2024, at 7:05 p.m. to see if the town will vote to amend the Plymouth zoning bylaw by adding a new district, Section 206.6, multifamily overlay district, and amend other sections of the zoning bylaw as necessary to create an as-of-right multifamily overlay district in compliance with the Commonwealth's MBTA Communities Law, Mass General Law 40, Section 3A, including establishing dimensional, affordable housing, signage, parking, and procedural requirements related thereto, and to amend the official zoning map, Sheet 2, to delineate the district or take any other action relative thereto. The full text of the zoning amendment and the proposed zoning map and other information are available and may be inspected at the office of Town Clerk, Planning Board Office, and the town's website. Any person interested in desiring to be heard on this request should appear at the time and place designated, the Plymouth Planning Board. Judy Barrett, are you speaking this evening? Or
Yes.
Mr. Hartman, you're going first?
Yes, just to introduce Judy Barrett. She's the principal of Barrett Planning Group, and she's been working with us very closely now since the summer on the MBTA community. So I'm going to turn it over to her, and she can make the initial presentation to the board. Thank you.
Thank you.
So, thank you. I think some of you probably know, but I have a 35-year relationship with this town, and it's always a joy to come back. So I'm here with some different hat on tonight, and it's about this particular law. So I'll walk you through kind of the basics about the law and how we got to the point of presenting tonight proposed zoning amendments to implement the law. So this goes back to 2021. The Economic Development Bill included a provision for housing choice that amended, among other things, the Zoning Act, which is Chapter 40A, by adding a new section that we are all calling the MBTA Communities Law. It applies to 177 communities around Eastern Mass and really out even to Central Mass, wherever there is MBTA-provided transit service. And the law has certain purposes, which I think will probably come as no surprise to anybody here. First and foremost is that we do have a housing crisis in Massachusetts, and I can tell you I work in New Hampshire and Rhode Island as well. The same conversations are happening in those two states. That there is a regional, really a wider metropolitan area problem going on with the inadequacy of supply to meet demand at all market levels. The other purpose of the law, obviously, is to encourage multifamily housing development, which is the basis for this particular statute, and in so doing, to boost the Commonwealth's housing supply. So those are the basic purposes of the law. This map is simply an illustration. You've probably seen this before. It's an identification of all the communities in Eastern and Central Mass that are subject to the MBTA Communities Law. And the different colors on the map simply represent the category of community that applies to you. You are considered an adjacent town, so that sort of lighter green that you see over Plymouth applies to, you know, many of the communities in the sort of outlying part of the region. So the basic provisions of the statute are that communities that are subject to the law need to have zoning in place that allows multifamily development on an as-of-right basis, which I'll explain more of as we go along, providing for at least 15 units an acre of multifamily development. The multifamily bylaw cannot impose any age restrictions on development, can't limit the unit sizes in terms of number of bedrooms or square feet, can't limit the number of occupants. It's truly kind of a market-based law. If you're a community that has a train station, you are subject to an additional requirement, which is that the housing has to be essentially within walking distance of a train station, and that the district has to be of reasonable size. And then finally, and I think this is really important because a lot of people don't understand this, the legislature created this umbrella law that really, these are the only specifics in it, and delegated to what we now call the Executive Office of Housing and Livable Communities the responsibility to develop guidelines that would determine whether a community is in compliance. So that was a decision of the legislature. I just want to make that clear because people sometimes have questions about the guidelines and where the authority comes from, and it's a direct grant from the legislature. This question sometimes comes up, well, what's a district of reasonable size? And the sort of default definition is 50 acres, which is roughly, if you drew a radius around a train station of a half mile, it's roughly what you get to is 50 acres. Or 1.5% of the community's developable land. So some communities have a greater requirement, some have less. A town that comes to mind with a smaller requirement is Rockland. It's because it's a smaller town, so their requirement is like 47 acres, I think, instead of 50. The other thing that the sort of reasonable capacity or district reasonable size has to address is this concept of zoned capacity. And simply stated, that is the number of units that the community's multifamily district needs to be designed to enable through zoning some number of units that could be built. So zoned capacity and this concept of the district size go very closely together. If you think about it, if you kept your district to 15 units an acre, Plymouth would not be able to get to the zoned capacity number that applies to your town. So you really have to sort of think about how you're going to design a district that complies with all aspects of this law, including this concept of zoned capacity. At least half the district must be contiguous. And the purpose of that is to make sure that we don't have districts that are just, pockets of land where there wouldn't be, any sort of rational basis for the development pattern. And then in most cases, including yours, the district has to, all aspects of the district, even in communities where there are sub-districts, like we're going to be talking about with you tonight, you have to have at least 5 acres that's contiguous in any part of the district. So that, again, you don't end up with these artificially small places where no one could really develop. So this zoned capacity concept is really critical to understand. It's the number of units that the Executive Office in Housing and Livable Communities, I will hereafter call them HLC for the sake of having an acronym, it's easier to say. That is the number of units that through their guideline development, each community was determined to have, their zoning must meet. And in Plymouth's case, that zoned capacity number is 2,807 units. So when we think about how to design the district and how to design the regulations, we have to keep that in mind, in addition to the 15 units an acre, the district of reasonable size. All of these things kind of accumulate to a picture that you have to be able to, I hate to say it, but check off all these boxes. So zoned capacity is not limited to vacant land, which I think is going to be obvious to you when you see what kinds of places are being proposed here. It's not a requirement to construct units. It's not concerned with existing units. So sometimes people will ask us, well, do we get credit for housing we already have? The law doesn't credit production. It simply requires the zoning district. So there's a big difference. The law doesn't require new development. It doesn't require your community to provide infrastructure to support the development. It doesn't override the State Wetlands Act. It doesn't override Title V. It also doesn't provide any specific options for waivers. So there are a number of opportunities and limitations associated with this law. Permitting can be subject to site plan review, which of course is what you have in front of you, so that you can regulate aspects of development that would be appropriate to regulate in a multifamily context or mixed use, as the case might be. And just thinking about the things you look at in site plan review, it's public safety, it's public health, is the provision for circulation on the site protective of pedestrians, bicyclists, and cars? Is there provision for screening adjacent properties? Things that you always look at in site plan review. You are allowed to look at those. But the permitting ultimately is as of right. You may require up to 10% affordable units, which is what is before you in your draft. And then the definition of affordable for purposes of the MBTA Communities Law is not necessarily confined to what we think of as affordable under Chapter 40B. Most communities are using that definition because they want any units created in an MBTA community zone to count toward the subsidized housing inventory. But I just want you to know that actually HLC did not impose any specific definition of affordable on communities. So the impact of noncompliance with the law, as we understand it, is that by virtue of what's in the legislation itself, communities become ineligible for certain grants. And those include MassWorks, what we used to call MassWorks. It's now just the so-called One Stop for Growth, the Housing Choice Program, and then the Local Capital Projects Fund. So those 3 grant programs are in the legislation as if you don't comply, then you can't qualify for these funds. Several months ago, HLC produced kind of an amendment to the guidelines to say not only are these certain 3 programs ineligible by law if you don't comply, but there are all these other programs that are under the executive branch of government for which communities will lose competitiveness points. So because your town has done so well with a number of grants, that you're scored based on how competitive the application is. So through the governor's executive authority, these programs were added as you're going to lose some competitiveness if you don't comply. Well, as I think you probably all know, Plymouth has made excellent use of grant programs here. This has always been the case the whole time I've known this community, but you had $2.3 million for the municipal vulnerability grants, both planning and implementation. You had coastal resilience. You've got ecological restoration grants, the Holmes Dam, Wareham Road, the boat ramp, Loring Road, and the seawall. I mean, all these, we couldn't put them all on a slide. They're just, the town's track record has been so impressive. So just to give you a little background about how we got to this point, we were retained, we do a lot of work for an organization called Mass Housing Partnership, and they've been providing technical assistance to communities to comply with this law. So the first time we worked with the town, it was under a, quote, Mass Housing Partnership grant. And through that, we worked with Lee's department to try to identify a variety of places in the town that might make sense. And they were a real mix of locations, some with existing development, some underdeveloped, some vacant. And we analyzed those through the model that is required by HLC, and then went out to do a couple of public meetings just to find out what people's questions would be, to try to get a little feedback on those sites. And those 2 first public meetings were on the 21st of August and then September 11th. In October, there was a joint meeting. My colleague Lauren was here for that because I was tied up with Plymouth, New Hampshire. But October 25th, you had a joint meeting of your select board and you folks, really looking for direction on what sites in that mix of 7 or 8 would be most agreeable from your point of view as the Planning Commission and the community. And based on that direction, we refined our analysis in what we call the HLC's compliance model, provided data to Lee, and also a draft of the bylaw, which went through a couple of iterations. And then here we are tonight, finally, with all this work has been done, so we're ready to present draft zoning to you. But I just want to make it clear to anybody who may not know that this isn't the first time this has been discussed in Plymouth. We've done, I think the town has done, not me, but the town has done a really good job trying to get the word out. So I'll talk a little bit about how we got, specifically what we did, so people understand the process for identifying and analyzing locations that might be appropriate for a district. HLC developed a compliance model that we are required to use to analyze the potential zoned capacity of a particular location. So the town picks the parcels, we don't pick them. We then review them in this model to try to determine if you zoned this for 15 units an acre, how many units would you get? And it becomes this iterative process of 15 units an acre doesn't get you to where you need to be on zoned capacity, so how much do we need to play with the density and how much do we need to play with coverage? You're trying to basically sculpt dimensional regulations that will get you to that zoned capacity number within roughly 50 acres if you can possibly kind of keep it in that level. So the tool requires skill in 2 areas. One is geographic information system technology, and the other is it's Excel. It's basically an Excel-based model into which we we review parcels that are identified in GIS and try to determine with the model what really could this district produce. If this were a district, what would it produce? So the most critical thing in this whole model, I can't underscore this enough, is this concept of zoned capacity. And the way the model works, it sort of determines what that will be based on what is the gross area of the parcels that you've given us. The model is designed to exclude certain land. It's not something we exclude, the model excludes it. So excluded land is things like permanently protected conservation land, public and private rights of way, institutional properties like the hospital. I mean, those properties all just come out automatically. So you start with parcels that may add up to 50 acres, but you actually end up with maybe 35. This is where it gets tricky on trying to understand, why do I have to zone for more than 15 units an acre? Because I've still got a zoned capacity number I have to reach as well. So the input assumptions you use as an analyst are things that you would put into any zoning. You know, well, what if the building height is 3 stories or 4 stories? Or how many parking spaces per unit are we assuming? The model penalizes you for excess parking. So you have to understand kind of how the model thinks through some of these dimensional requirements. The model will allow you to make an assumption about maximum lot coverage. And there are a few other things, kind of depending upon your own ordinance or bylaw, that we would look at in order to kind of make this model tell us, what does it take to get to, 2,807 units? That's the real big question in all of this. So do you want to address the sites? Why don't I turn this over to you at this point?
So I'll just go through the sites and explain again the sites. And I would point out at that joint meeting with the Planning Board and Select Board, when we asked for some direction from the community or from the boards about how we should, as staff and consultants, approach this, the direction we had was do the, lack of a better word, the minimum necessary. Locate these in areas that really have already done, take credit, let's say. Take credit for the multifamily development that has already existed in town. And then the second thing was, as much as possible, locate this development in the northern part of the community. So the first site we have is the Cottage Park site. And if you look at the zone, it's not all of what we know as Cottage Park. It's really the area where the existing 2 multifamily units are there, and then the other part, which is the warehouses as well as the area by where the old smokestack was, that has all been identified for development under the 40R district. That's already been approved by the town for 675 units.
So it's the built environment that's there.
The built environment, that's either the built environment or the vacant land by where the smokestack was that is already pre-approved for residential development. The second site is the site off of Commerce or Plaza Way. So this is the car dealerships here. These are the Dick's Sporting Goods in Colony Place. This is the Kingston Town Line. This is Route 80, Plimpton Road, and then this is Commerce Way here. And so we're talking about the area that includes the Walk 40B, which is mostly constructed, parts of it occupied, the Sawyer's Reach development here, and then the Claremont property, which is approved. And I should point out that we have just had conversations, and the Claremont people have indicated that they are now going to shift gears, and we should be expecting a 40B to be filed, a different project, different parameters on that site, but that should be coming in sometime in the near future. But again, this is the site where we have either all that development already done or projects that have been approved. Third site is the Oasis off of Long Pond Road, so Route 3 here, Long Pond Road is down along here, and this is the Oasis project off of Long Pond Road. And then the last one is the multifamily that we already see, and I can show you, I have a couple slides at the end if you want, that shows the built environment, but this includes the New Hanover project that's back here, the Mark and Avalon property, and then extends over through to the new Brizzuto property in the Pine Hills. So those are the 4 sites. And when we run through that and use the model that Judy explained and the parameters, the different requirements that you see in the text of the bylaw you have tonight, this is what we come up with, so we have something that does comply with MBTA communities.
So if you're looking at this total and saying, why isn't it 2,807? I'm here to just testify that it's impossible to take any parcels and somehow tweak this zoning enough that it just adds up to that number. So we got within roughly, I guess, a little less than 10% of the requirement, and that really was the best we could do. We spent a lot of time looking at alternatives for coverage and so forth, and this is where we get. So it works. It does comply. Oh, sorry. So the proposed zoning that you're looking at contains 4 sub-districts. The reason we would do sub-districts is that they're not the same areas. You know, you folks on the planning board know all 4 of these locations. They're different. It doesn't change the underlying zoning, which one would expect for an overlay district like this. There are different dimensional and density requirements for the sub-districts based on the modeling. So understand, we were trying to stay as close to your zoned capacity number as we could. So we literally played with each sub-district a bit to try to get something that would work and still ultimately get you to that zoned capacity number. It sets basic standards for things like off-street parking and building placement and so forth. It relies on your existing zoning bylaw for other provisions that really don't need to be in the overlay, such as you have existing requirements around landscaping and lighting and signs, so you wouldn't want to disturb those things that you're already working successfully with. It's been reviewed by town council, and I think the expectation is that if this is approved at town meeting, we do have an architect on our team who would be helping to develop design guidelines. They are, of course, advisory, not mandatory, but design guidelines for these sub-districts. So if something does happen, at least you will have some guidance, and a developer would have guidance on what it is that the town is looking for. So down the road, you'll hear from the architect as well, but it's premature at that point to do that. So I think that's our, oh, go ahead.
Just, if I could, just a couple things to add before we have public comment and comment from the board. So first of all, I want to just note that this is mandatory. So this is not something that the state is saying is voluntary or your option. There are penalties if you don't comply, but they are saying this is mandatory. In addition to the grants that were mentioned, there could be legal action to any town that fails to comply. Second thing, just to note that the way this is worded and drafted today, this is a majority vote at town meeting, not a typical 2/3 vote. So I think those are 2 important things. The other thing is, about a month ago on January 4th, we sent you a draft of this bylaw for your review. I will note that the biggest change, so there's not a lot of changes, there's a lot of text that was removed, but that text was related to what we tried to do at first was build in a site plan review where this board had the ability to say yes or no to the site plan review, unlike the one we do and then we have used for 30 years, which is advisory. Town council recommended we remove that. Her concern is that because there was the ability for a potential denial or the ability for an appeal through that site plan review, that could risk the Attorney General not approving this bylaw. So the bylaw you saw on January 4th is really essential. It is the same bylaw, except that provision for that discretionary site plan review that we tried to put in, council has strongly recommended that we remove it. And then my final comment that I want to make is that the way this has been drafted, the public input we have, the guidance we've had from the planning board and the select board, really I do not anticipate to see any significant development, if any at all, from this. So I think the way this is done with your guidance is to take credit for what we've already done for multifamily. And again, I don't see a huge impact occurring in the community based on the way this is, the guidance we've been given and the way this has been laid out. So with that, thank you very much. We hope that you are willing to move this forward to town meeting for April.
Thank you very much for the presentation. Obviously, a few things have been updated, like our non-ability for site plan review and approval, right? So this is mandated, no review?
There will be a site plan review just like every other site plan review you do. The difference was the way we tried to do this was to say that you had the ability to deny a site plan as a board. Council says you should not have that in there. You risk having this defeated by the Attorney General turning it down. So you still have the site plan review just like every other site plan review you've done, and so it'll be that process. It just won't be a site plan review where you would have the ability as a board to vote no on it, or that it could be appealed by.
Right, and you also stated quickly that there was no appeal process whatsoever after this was approved at town meeting. Just want to make that clear to everybody. Okay, before we start discussing this as a board, we always go to the public for public comment. So is there anybody here who wishing to speak? Yes, and reminder, you only have 3 minutes to speak.
Oh, I took your mic.
I restarted the clock for you.
Thanks. Mark Pacheco, 11 Timothy Lane. First of all, great job with what looks to be a very difficult law. Should the MBTA service resume, does this envision that?
No, it does not. So should the train station in North Plymouth open, we will have to go through this whole exercise again. Our number will shift from 2,007 units to 4,200 units with a requirement of a significant amount of that being within that half-mile radius of the train station. So it will be a very different process that we'll have to go through if that train station opens. I would say that if there's discussion and the possibility, my first step either through us, through town council, or through our delegation is to plead with the state to say, shouldn't there be some kind of grandfathering provision? The indication we have so far is that no, they wouldn't do that. But again, if the train station opened, we would first try to do that. If that didn't fail, then we will go back to the drawing board and look to see how we could address it at 4,200 units.
Is that what the number is, 4,200?
Something like that. I think the great challenge in answering any of the concerns right now about the closed train station is that in the time I've been working on this program for, 15 months, the guidelines from HLC have changed 4 times. So I would just encourage you to not worry about something that hasn't happened yet, because if that does happen, we don't know where the guidelines will be at that point. There's a lot we don't know, except what we do know now is that you are classified as an adjacent community. It is our opinion that this bylaw will bring you into compliance based on existing conditions. That's really all you can deal with right now, and that's no disrespect to your question, it's just we don't know.
Okay, thank you. Anyone else here this evening wishing to speak?
Hi, Hampton Watkins, 31 Cornishfield Road. In one instance at least, at the Pine Hill site, there's already an overlay district there, so you're proposing to put another overlay on top. Is there any issue with that?
So the Pine Hills is not an overlay district, it's just simply a special permitted use. So we've had the discussion, and actually when we first looked at this, and I thought we'd have a real struggle.
Hey, Lee, could you
requirements.
turn this way so I can?
It was
Yeah.
the
Thank you.
state themselves who recommended we look at facilities like this. So I think we're good with that because it's a special permit, not an overlay district.
Okay. Thank you. You're welcome. Anyone else wishing to be heard, please?
Thank you. For the record, Lauren Tripp, Precinct 3. I have a couple of questions, which should be somewhat self-explanatory. When you looked at the modeling, we look at the 15 units per acre is a minimum. That tends to leave that there is no cap on density. Have we looked at these areas to determine what the maximum capacity or density could be, or any unintended consequences of this zoning overlay? That's the first question.
just a little bit
Before
hard
you
for-
answer that, Lauren, do you have any other questions to go along with that one?
That's the first question.
You have
The
other
second-
questions, so we'll answer them all at once versus
Okay.
going back and forth. Go ahead, Mr. Tripp.
Well, they may lead into the second question, but, so, in regards to that, so looking at what these specific areas are, because obviously you've got room for growth right now, that there's existing permitted development that's not currently under construction. So there's that question. Secondly, not having any authority over the approval process or site plan approval. Was there any discussion with the landowners that they would enter into some sort of an agreement with the community to set caps and parameters for their development for exchange of the overlay? Because technically the overlay is an upzoning and it's an increase in value of those real estate properties. So that is one. And then thirdly, when we looked at, if we look at what that potential growth beyond what the minimum 15 units per acre is, did we look at the surrounding infrastructure and its capacity to handle any unintended consequences and additional zoning that may occur because of those developments? That's it.
Thank you. Could you answer
So
Mr.
I
Tripp's
can
question?
answer the first question I think I heard you ask, which was if we stayed with 15 units an acre, you would have needed way more land. Because 15 units an acre at 50 acres doesn't get you to 2,807. So this was one of the great challenges with this, is if we try to stay close to kind of the land you need, we have to go up in density. If you wanted to stay, I should just also tell you, none of these are actually 15 units an acre, because you lose too much land in that excluded land process I described. So you won't, I think, see any of these that are any less than like 16 units an acre. So it's a complicated model, but I would just say we would have needed more land. And if the goal was to try to target these districts, these sub-districts, in locations where the built environment's kind of there, then it's kind of hard to find many more of those. So that's how we ended up with the density that we have.
The final question, brief, is that in regards to doing this, where we're kind of skirting the original intent that the state had to create additional housing and increase housing stock, we're not doing that, obviously, because we're using what's already been existing permitted. Is there any other town that's done the same strategy and succeeded and been approved by the Attorney General? Because, as you said, that the rules have changed 4 times, and as more communities attempt to do the shell game that we're about to try with the state, is there any successful models, or will we be the creation of our own demise?
Lauren, what's the question? We get directly to the question versus, please.
It's a simple
We're good?
question. Is there any other town done this and got
Yep.
away with it?
Okay.
Lexington.
Okay.
They were the first ones. And it's all in locations where there's existing development.
And again, I would point out, especially for Plymouth being one of the fastest growing communities in the last 5 years in Massachusetts, we are really doing what they want. We've already done what they wanted, and we're just simply taking credit for it. I think that's the way to look at this.
Okay, appreciate your questions.
No, thank you.
Anyone else here this evening wishing to be heard?
So,
One more time?
anyone on Zoom? I'm not seeing anyone.
No one on Zoom. So we can bring it back to the board. If we'd like to leave public comment open in case any other questions come up, or we can close the public comment section of this hearing. What is the pleasure of the board?
I think we should keep it open at this point.
Okay. All right, so I'll go to Ms. Keene first, please.
All right. I'd like to just have an answer, because I'm going to state the obvious, but sometimes it hasn't really been
So
that
can
obvious.
you just talk straight into it? It's, again, kind of echoing.
Oh, well, I'll do my best to do that. I don't know where to place this. In other words, with our 4 zoned districts, MOD, we're calling them, we actually do not have to, when we zone, we don't actually have to build anything because we're over the 2,000 plus 2,807 into the 3,000 units within those? Or do we have to
No,
build
so
in
the
order to
law,
meet?
the law only speaks to zoning. There's nothing in the law that says you have to create a single unit or that you have to use the units. The law only says you have to put in place zoning. So we happen to put it over where existing development is, but there's nothing in this law, and there's not a single requirement that even one unit be built. So the law is really just about zoning.
So if the law is about zoning, and I'm just sort of going through this because it's the type of questions that I get from people when I'm grocery shopping and they stop me. 2,807 represents something. It's an accounting. So within the zoning, we have to be able to build or have had built close to 2,807 units. And the zoning will accommodate that. Whether they're ever built or not is not a concern. Am I stating that correctly?
Yes, and I'll just point out that 2,807 is 15% of the existing housing stock in the town of Plymouth. So that number is derived by, they had the two things, the 50 acres, and then they also said that every community must have a capacity of 15% for us. It changes by whether you're a commuter station, whether you're a small or a large town, or whether you're an abutting. But in our case, it's 15% of the existing housing stock.
When we file this with the state, our plan, and go for approval, it's my understanding that this could become a moving target if we're on a percentage of our housing stock, or does it remain for a period of time? Would we be required to zone more?
So I'll have Judy do the second part if she has any knowledge, but this is based on the 2020 census. So at
All
the
right.
very least, it never moves
20
until 2030.
30,
I don't know if anybody's ever discussed with you what happens with the new census.
No.
No, okay. Well, that's kind of a safety place, right? And let's see. One thing that I wanted to mention, and this is probably out at left field, but can we count for our, well, okay. I'm gonna withdraw that question because I was talking about some as of right. Could we add it to it without the zoning? But no, it's just a zoning. That's it. Okay. I think that's all the questions. There was one place where in the writing it talked about 35 feet being 4 stories, or there was something that was a little bit
So the bylaw speaks to 45 feet. So the
45
height
feet.
limitation here is 45 feet. And if you'd like to, I actually have a little table I put together of the heights, and the heights are all already in these areas
right.
consistent with that 40. In most cases, it's higher than that, but it's consistent
Yeah,
with
buildings
that.
like the
But
Hanover.
it's 3 stories, so not 4 stories, 45 feet.
3 stories at 45 feet?
Yeah.
All right. I always equated the 35 feet with 3
So
stories.
the challenge, and again, Judy can talk to this better than I can, but I think the challenge is if you say 3 stories, 35 feet, you're encouraging flat roof buildings. So the 45 is going to give
It
you...
allows for architectural detail. All right, that makes sense. And on the applicability, which is on page 1 here, the last sentence, you say, where the MOD requires a special permit, the planning board shall be the special permit granting authority. I thought that the whole idea of an MOD is that it doesn't require a special permit. So it's page 1. It's the last sentence on the page.
So you can't require a special permit for a minimum of 15 units an acre and a district of reasonable
Right.
size for 2,807 units.
Oh, I understand that, but the way
But
this is written,
if-
why would
because-
the MOD require a special permit?
Only if you were allowing something in addition to the minimum requirements you have to meet.
It's a little bit of a confusing
And a
statement.
good example could be a waiver of parking. So suppose they came in and you're requiring in this to do 1.5 spaces per unit.
Mhm.
Suppose they decided they wanted to do 1 space per unit. that would trigger the special permit. So there could
Within
be,
the MOD, and you can address
There could be
that.
some things they want to do above and beyond the overlay district that might require that. That maybe there's a special permit for a side yard setback variance, not variance, setback alteration. Maybe they want to go to 46 feet instead of 45. So the special permit there is to say, here's what you can do as an allowed use, but there could be certain things beyond that that would trigger a special permit.
Now it makes a lot more sense. Just this short sentence, maybe you might consider an asterisk where you give an example, because it's a little bit of a confusing sentence. Thank you very much.
You're very welcome. Carl? Oh.
So basically, some of the crowd did answer a few of the questions I had, and that was the biggest one, and was in regards to the T. Now if we have to go by Kingston, the amount goes higher. Is that because we come into a different category?
So not Kingston has nothing, so Kingston deals with now because we abut Kingston.
Correct.
We're an abutting community, and so we have a lower threshold than if we actually had a station.
Okay,
right
so
now-
once the station opens in Plymouth, we have a higher request. Okay,
If
I had
it
it.
happens, yeah, we would have a higher number, and again, that's uncharted territory. We'll have to see what happens if that happens.
Right. No, I had it reversed. I just wanted to clarify that. And then, explain to me the 50 mile, what was it? No, was it half mile?
So-
And you mentioned something, sorry, you mentioned something about walking distance in the report too. Do all 4 of those sites we propose, are they also meet that category as well?
So the half mile refers to a half mile of a train station.
Transit, okay.
So if you're not a station community, that doesn't apply. The 50-acre minimum was determined based on a rough computation of if you had a station and you drew a half-mile radius around it, how much land is that? That's how HLC came up with 50 acres.
But I'm just trying to comprehend 50 acres because with Massachusetts already having an issue with land and being able to develop on that, 50 acres is kind of a wide circle, in my opinion.
Well, that's what the standard is. I mean, I
Yeah, no, I
can only
understand.
tell you what it is.
I'm just,
I'm in a
yeah.
funny position here where I have to tell you what the requirements are. I'm not necessarily going to be able to justify them, but that is the standard.
Okay.
I think both of us have our own opinions about much of this. Some of it conflicts with each other, but we both have our own opinions about this whole process that we are undertaking as a town and as a Commonwealth.
So I also want to say thank you for the work you've done on this. I've had to deal with GIS and just trying to do the overlays and trying to come up with the formula. I'd rather shoot myself in the foot and walk 10 miles. So I understand where you're coming from and how difficult it is to put that together. And also my understanding is that according to the model, it doesn't quite add up to the guidelines?
It exceeds it.
Exceeds it, okay.
By about 215 units, I think.
Okay, perfect. Thank you very much. I appreciate your time.
Thank you.
Thank you, Kyle. Mr. Bolton?
Thank you, Mr. Chair. Just the one quick question. Based upon the bylaw that we're proposing, what is the density, the units per acre that we are seeking for approval from town meeting to go into our bylaw?
Go ahead, you do it. It varies. It's down here.
Yes, so on page 2 of the bylaw, it varies. So if you look at page 2 of the bylaw at the very bottom, maximum units per acre. Cottage Park is 20 units. Home Depot Drive is 15 units. Plaza Way is 20, and Pine Hills is 22.
So if we were to expand the districts in the future, if necessary, based upon changes in the law, we would then essentially come to a density based upon an individual site rather than a singular density throughout town based on the bylaw. Is that correct?
Yeah, I don't see us, there's no need to change this in any way. But yeah, I think if we wanted to either voluntarily or if the laws change, add additional areas, it would be completely up to us how we want to do that. I would also say that if we wanted to do something once we meet this, that was at 10 units per acre, there's nothing that prohibits us from doing that totally separately.
Thank you. That answers my question.
Is that it, Steve? Do you have anything else, or is that it? You good? Okay,
I'm good. Thank you, Mr. Chair.
you're very welcome. Rosemarie?
Thank you for the presentation. Thank you, Mr. Chair, but all of my questions have been answered. Thank you.
Okay, thank you. All right, I have a question as far as, one, when you look at we talked about the heights at 45 feet for 3 floors, but there are exceptions underneath that paragraph that read vertical projections, roof structures, elevators, stairways, tanks, ventilating fans, or similar equipment can exceed the 45-foot height, correct? As long as it doesn't constitute over more than 25% of the ground floor area of the building. That's what I'm looking here and what's being presented. So there is, if you're doing a cupola and it happens to be less than 25% of the floor area of the building, it can go over the 45 feet. But by how much can it go over the 45 feet? That, and my question is also the design guidelines. Are they going to be design guidelines for each individual area? Because they're in different areas of the town.
There'll be one for each of the sub-districts.
And
those will be approved by you.
so we have yet to do the design guidelines for this particular article.
Right.
That's going on the town meeting floor.
Yeah,
And
we'll talk about that, and if the board chooses to move forward, I think we'll start to talk about that now. I think there's time that we could start to do it. We didn't want to do anything not knowing where we are at all.
Right.
So we have this tonight, if the board is willing to vote and support this, we are on cue for the select board Tuesday night and Finance and Advisory Committee on Wednesday night next week.
right, so I think that's
Again, depending how that all goes, we could start to put that design guideline discussion that again would happen with you as a board into higher gear, so that's ready to go.
right. So
And we
within,
have consulting money to do that too, I'm sorry.
Yeah.
right, okay. So within those 4 areas, we're not restricting builders to do less than their requirement of 15 units within these guidelines and these tables out of here.
It's up to the developer.
It's up to the developer on what they want to do. So the 4 areas that we have selected, how much credit do we have? Is it the full 2807 are we talking about?
What was the number you had?
What was the
I
number?
forget, actually, I'm sorry.
3,207, so we're over the amount by the credited numbers that we have. So the gray area, obviously, if they decide that, what if this station, which isn't operating at all, if this opens up selectively 1-2 days a week, or
Again,
at
we'll
one
have to
time
talk
during the
about-
day?
That's a whole new ballgame, we'll have to have that whole discussion. Yeah, so if they're only open like on Friday, Saturday, and Sunday. So if they're open, say Friday, Saturday, and Sunday, we'll have to see, again, we'll have to have that whole discussion.
I would hope that wouldn't affect
Yeah,
it,
we'll
but
see.
we'll have to cross that bridge when we get to it, I guess. Huh? Well, when the train crosses the bridge? Okay. All right, so those were some of my concerns, especially the design guidelines, and just making it clear that they can go over the 45-foot height per the document we're looking at here this evening. That's all my questions, and I want to thank you for the presentation, all the hard work that's been done, the public outreach. We're here this evening listening to former chairman of the planning board, Mr. Tripp, sitting out here in the audience, asking some fantastic questions. And the entire board has asked some great questions throughout the process, to include the Board of Selectmen when we had the combined meeting. So this is a step to me in a positive direction. We need to do it or we lose funding for grants, as you mentioned and shown on the slide here this evening. So are there any other questions from the audience first, or comments? Anyone on Zoom?
Anyone on Zoom? I've not seen anyone.
Any other comments or questions from board members? Seeing none, I would entertain a motion to close the public comment first.
Motion to close public comment.
Second?
We have a motion and a second to close the public comment. Mr. Bolton?
Yes.
Ms. Keen?
Yes.
Mr. Donaldson?
Yes.
And myself, yes. Now I'd like to entertain a motion from the board. What is the pleasure of the board on this article that's going to town meeting?
Well, I move to approve, but I still would like to add that there be a clarification of the sentence that allows the special permit within the MOD.
Can that be done?
Yes, so, we'll have to look at that, but yeah. So it wouldn't necessarily be an example, you wouldn't put an example into the bylaw, but we can figure out with council language that makes it clear that it's special permits for those incidental uses.
Right, because you go to a lot of trouble to say there is no special permit, it's as of right, and then stick that sentence in and it's confusing. So, otherwise, motion to approve with that addition.
And the writing of that addition would be reviewed and approved by?
The what?
When you write this amendment or whatever you want to do to this
So
language.
we will just, again, I think it's fairly minor, so we'll just email it to you guys so you can see a red line change.
Okay. All right, so we have a motion
You wanna
with
just-
a
So
minor.
so Judy just said, or we could just strike that whole section.
And then address it when something
Yeah.
comes before us.
Yep. So if you'd like to do that, we can strike that and go with that.
Yeah, because we're going to approve something that's going to go to town meeting this evening. I'd kind of like to see whatever language would be there, and if you're going to strike something that I know it's going to be stricken.
I don't think it's essential, and if she's comfortable with it, I am too.
Yeah.
We can just
I'm-
strike that whole piece.
If you know town meeting, it's just some little inconsistency, and they're gonna, you're gonna have 10 people at the mic.
Yep.
Yeah.
Okay, so we have a motion to approve striking that particular section. Do we have a second?
Second?
We have a motion and a second. All in favor? Mr. Donaldson?
Yes.
Ms. Keen?
Yes.
Mr. Bolton?
Yes.
And myself, yes. Thank you very much.
Thank you.
The next item on our agenda is another public hearing, which I will read into the record. The planning board will hold a public hearing in the 1820 courtroom, Town Hall, 26 Court Street, Plymouth, Massachusetts, on Wednesday, January 24th, 2024, at 7:05 PM to see if the town will vote to amend its zoning bylaws governing ground-mounted solar photovoltaic systems, Section 207-11. The intent is to ensure that when there are nearby residents who are not naturally shielded from a proposal, a plan to adequately do so must be presented to the planning board, who in turn must, and the must is capitalized both times, make the implementation of such a plan a recommendation to the building commission. This plan further makes changes to the financial surety section of the bylaw concerning bonds and adds language to the abutter notification requirements. Text map and other information may be inspected at the planning board office. Any person interested in desiring to be heard on this request should appear at a time and place designated. Plymouth Planning Board. Good evening, sir. How are you?
Good, how are you?
I'm having deja vu.
Yeah, at first you don't succeed, try again.
Right.
Although people also say quit while you're ahead, so we'll see. Mark Pacheco, Precinct 4, here tonight on behalf of the amendment. basically, know this has in no way is an anti-solar. We don't hope at all to hold up any solar development. It's crucial that these things happen. All this does is makes a few changes and adds a new section, which helps ensure that residents are protected and puts the onus on developers to do so. So it's not on the board. So let's just jump right in. The first change is with the bond. Currently, the bond is based on anything over 2 megawatts that produces more than 2 megawatts of power has to put forth a bond. That is based on technology. 2 megawatts when this was written may have been 10 acres or something. Now it's maybe 6. 10 years from now, maybe it's, you know, something you can put on your roof. So it really shouldn't be based on technology because that's not the concern when you have a bond. The concern is something large that's there. The developer skips town and the town's got to pay to take it down. So we're changing that from technology-based to size-based, and we're using 4 acres, my 4 acres. We didn't want to go so small that we were putting an undue burden on a developer, but we also wanted to ensure that anything that was really sizable did fall under this category. So we landed on 4 acres and working with planning. Mr. Farrar is fantastic to work with. So you can visualize that. 4 acres is about the size of Walmart Supercenter. It's about 274,900 feet. So that's the first change. Second change. Some of you will recall last time we had put forth an amendment to this wherein we changed the notification laws for solar to 700 feet. A lot of pushback on that. And I understand why. However, we still feel like it's something that's important. So again, in working with planning, we came up with a sort of a compromise where we're adding a new subsection which is telling developers that when we have a situation where there are people who certainly will be affected, impacted, that are beyond the 300 feet, that we're urging them to notice those people as well. This does not have any force of law, and I understand that. But what I hope it does do is signals to solar developers that we are serious about letting our neighbors know what's going on around them. And I hope it does in the future start a new conversation about whether or not certain things should have larger notification. That's not for me to say tonight. The last thing is a new section, standards and conditions. This section last time relied on something, a term, view shed. I admit to being way too cute with that last time. That's my fault. No more view shed. Instead, I'm going to go right to the law itself. The intent of the law, Section A, intent, the intent of this bylaw is to promote by right, subject to site plan review, et cetera, et cetera, et cetera. And then it gets to this point, and to minimize the impacts of solar facilities on the character of neighborhoods, on property values, on the scenic, historic, and environmental resources of the town, and to protect health and safety while allowing solar technology to be utilized. Okay. When we go to our new section. Standards and conditions. When site plan review is required, exempting the municipality, I think it's important that we ensure the town can do as much solar as possible, or a ground-mounted solar facility proposed designed to cover a parking lot. Again, I think that's important, and if you have a parking lot there already, you don't really need screening. The following shall apply. An applicant shall present to the town for planning board review and recommendation a stamped engineered plan which includes screening as defined by section 2013 of the bylaw, which accomplishes the goal of largely minimizing the impacts of solar facilities on surrounding residential properties. What are the impacts? I just read them to you. They're in the intent of the bylaw itself. Subsection A, as determined by the planning board, following the input of inspectional services, said residential properties shall be defined as those more likely than not to be impacted with regard to the character of the neighborhoods, on property values, and on scenic, historic, environmental resource of the town. What we're really doing here is we're taking the screening section and we're taking the intent section and marrying the two together to give them a stronger force of law in a new section. So that if I'm a developer or I'm an attorney for a developer and I'm seeing this, I know this is something the town is serious about. Next section, the planning board may waive this provision for particular abutting property if the applicant attains notarized written permission. I think if it's only affecting one person, that person doesn't care. We don't need to put the burden on the developer to do a screening if it's not needed. Lastly, as per 207-11C2G, planning board shall make a recommendation for screening, which largely accomplishes the goal of adequately sufficiently reducing the impacts. So what are we saying here? The developer has to walk in with a plan. Planning board has to make a recommendation that includes a plan that'll be on the stamped engineered plans. So, this started because of something on a Black Cat Road. The plans have no screening on them. So I will say this, so you all know, the developers out there have graciously agreed to work with us to do screening after the fact. So they are doing due diligence. Sarah Stearns has been instrumental in that. I just wanted to put that on the record so everybody knows. Last section, severability. We have added that as the last time we had to come back with an amendment. We're adding it in here now. So that's that.
Okay, thank you. First, I'll go to Patrick Farhar, please.
Good evening, Mr. Chairman. So, after the fall town meeting, this petition article had failed just by a few votes. I forget how many, 3. Staff approached Mr. Pacheco and kind of suggested that if they wanted to move forward, we would be happy, this office would be happy to sit down with the petitioner and kind of go over line by line, and that's exactly what we've done. Also, something that was not mentioned is that throughout this process, Mr. Pacheco and the petitioner has gone before the Energy Committee probably at least 2 different occasions since the fall town meeting. A letter was drafted of support from the Energy Committee reflecting this new proposed language. Going over all of this, Mr. Pacheco was very clear with all the different insertions as well as deletions. Staff does not have any objection to this language moving forward to town meeting. But we think that it's reasonable. And it does give the planning board a little bit more, I don't want to say bite, but a little more authority on the screening measures. While it's always been in 207-11, this kind of provides a little more clarity.
And if I could add, it was a unanimous vote of support before Energy.
Unanimous vote by the Energy Committee?
Correct.
Okay.
Support.
Thank you. All right, before we bring it to the board, obviously, I'd like to bring it to the audience here this evening, or the public, Anybody wishing to speak on this article that's going to be going to town meeting? Seeing no one? Anybody on Zoom? Nobody? Okay. It's just us on Zoom. Okay. I see Steve. All right, Carl, please. Any comments, questions?
No, I actually met with Mr. Pacheco and had a chance to look at a few of these things. I have no objections. I believe they did a good job coming back and strengthening the language based upon our last conversations in front of the board. And so, and I also want to thank you for your time and your effort in this adventure. And I'm in support of the language that's in front of us today. Thank you, Mr. Chair.
Thank you, sir. Steve, please.
Thank you, Mr. Chair. I'll echo Mr. Donaldson's statements with respect to the level of support and my appreciation for the petitioner working with town staff to address some of the questionable areas from the prior draft. I do have some reticence about the elimination of the greater increased notification area. That was something that I favored simply because it promotes transparency, something that this board and other boards as well in town have heard repeatedly from our community they want. And there's nothing more transparent than making sure that people know what's going on. Obviously, that's something that may not be addressed at this point, but certainly something I'd hope that the board may take up again in the future as we think about who really needs to be noticed when we start talking about large-scale projects. Thank you, Mr. Chair.
Thank you, sir. Ms. Keene?
Thank you. Mr. Pacheco, I and Energy Committee, I'm really quite happy that you listened about the slippery slope that was embedded in the view shed, and that we would have been a first in the country using that term in this manner. So I have no concerns or objections for taking this to town meeting as written. Thank you.
Thank you. And I did meet with you gentlemen and the petitioner on the first rendition, and I supported that one. This one's even more tighter, and the questions from town meeting have been addressed to include the view shed comments that were in the original one. So I am in support of what you're presenting here this evening, and I'll be voting in favor of it. Anybody else have any other comments? Board members? Anybody? Okay, I'll entertain a motion to close the public comment first, if we could.
So moved.
Do we have a second?
Second.
We have a motion and a second to close the public comment. Mr. Bolton?
Yes.
Ms. Keene?
Yes.
Mr. Donaldson?
Yes.
And myself, yes. Now I'll entertain a motion to support what's being presented to us this evening and being sent off to town meeting for their approval.
I'll make that motion, Mr. Chair.
We have a motion, and we have a second. All in favor? Mr. Donaldson?
Yes.
Ms. Keene?
Yes.
Mr. Bolton?
Yes.
And myself, yes. Thank you.
Thank you very
Good
much.
luck at town meeting.
Thank you.
I'm sure staff will be going to some of the precinct meetings,
Yeah.
right?
In fact, I'm going to be precinct 6 and precinct 3 Thursday night.
Okay.
So if you want to come, bring coffee.
What do you say, want to come bring the coffee, is what you said? Yeah. Okay. Black, or what? Yeah, black? White, want some cream, maybe a little sugar? I can't have sugar, I have diabetes, so I gotta stay away from the sugar. Okay. So next on our agenda this evening, we have ZBA 4117, 8 Honeybee Lane, special permit required per section 203-9, and dimensional table R-020MF to waive front setback to construct a single-family dwelling. Good evening, how are you?
Very well, thank you. Good to see you, folks.
Good to see you, too.
Yeah, Mark Flaherty for the owner of this property off of, it's 8 Honeybee Lane. Honeybee Lane is in the White Horse area. It's in the R20 district. Susan bought this lot with the hopes that she could do something for her disabled son. It was apparently kind of an inexpensive lot at the time. There was a house on it. The house was in a dilapidated state. She took the house down, and so as you can see by the plan in front of you, but the plan that's on the screen, it's a unique shaped lot. It's about 5,900 square feet. It's served by town water and an on-site septic system right now. We're trying, Susan reached out to an architect, Gordon Noseworthy from Pembroke, to design a relatively small house, 22 by 24. There's a deck on the back. In order to really site this house on this small lot with its unique shape. We require a waiver from the front yard setback from 20 feet down to 10 feet. This is really the only location on the lot where we could put this house. And there is no environmental concerns. It's not in the floodplain. It's just high and dry. In my opinion, it's not going to affect the neighborhood, and we feel that the waiver, the special permit for the waiver of the front yard setback should be serviced for the small lot, 2-bedroom. There will be a 2-bedroom deed restriction placed on this house and this property, and Susan would be delighted to be helped out, and we're looking for your support. Thank you.
Thank you very much. Anything from staff, please?
Just briefly, just to reiterate what Mark said, this is a pre-existing non-conforming lot, and that whole area is very prevalent in that area for very small lots. So this is not unusual to see this kind of situation here. And as Mark mentioned, not only the triangular shape of the lot, but also the septic system that was located in the front really does limit the location of where the house can go. Thank you.
Okay, thank you. Again, before I bring it to the board, even though this is not a public hearing, is there anybody here in the audience wishing to speak this evening or ask any questions? Seeing no one, and there is no one on Zoom, right? I'm feeling kind of lonely. Not used to it, right?
There'll be another night to make up for it.
Oh, I'm sure. Okay, I will bring it back to the board. Mr. Bolton. Steve,
Thank
you
you,
did?
Mr. Chair.
Yep.
I am here.
Okay.
One very quick question. What was the size of the original house that got torn down?
About the same size, Steve, approximately 20 by 24.
Thank you very much, Mr. Flaherty. That answers all my questions. Thank you, Mr. Chair.
Thank you. Mr. Donaldson.
Actually, I don't have any questions. I know this is pretty standard for that area. I'm down in that area. So as long as it meets all the other zoning requirements, I don't have any issues. Thank you.
Thank you, sir. Ms. Keen?
Thank you. It's nice to see you looking well, Mr. Flaherty.
Yeah, thank
We're
you.
used to seeing your son these days. I have no questions. It fits the neighborhood. All of us are very familiar with the area, and it's a nicely designed home, and I'm hoping that the occupants will enjoy it.
Thank you,
Thank
Brigida.
you.
Thank you. Rosemarie?
I have no questions. Thank you, Mr. Chair.
As well, I have no questions.
Good.
And I wish the homeowner a lot of luck. And again, we are only advisory to the Zoning Board of Appeals. When are you going to the Zoning Appeals on this one?
Is it next week, Robin?
Next week? Okay,
Next
well,
week. Next.
good luck on
Yeah, thank you.
February 5th. I have no questions. Okay, I'll entertain a motion.
Week from Monday.
I would like make a motion to approve.
We have a motion to recommend approval to the Zoning Board of Appeals. Do we have a second?
I'll second the motion.
We have a motion and a second. All in favor, Ms. Keen,
Yes.
Mr. Donaldson,
Yes.
Mr. Bolton,
Yes.
and myself, yes.
Well, thank you very much.
Thank you.
Thank you.
Have a
Thank you.
great rest of your evening. Last, but certainly not least, we have a ZBA case 4115, Bid Hospital, Plymouth, 275 Sandwich Street. Special permit required per section 205-4, R25, and use table to expand an existing hospital special permit use. Per section 203-7F, period 1, to waive required parking space width. And per section 203-7, period J, table 3, to waive number of required parking spaces if required. Good evening, sir. How are you?
I'm well, Mr. Chairman. Hi, everyone. Nice to see you. Save the best for last, right?
That's right. Absolutely.
Yeah. For the record, Attorney Rob D'Ambroso Law, here in Plymouth. I'm here on behalf of the hospital, Beth Israel Deaconess Hospital, Plymouth. I've got Mark Tarleton, the Senior Facilities Director, with me here, and he's going to contribute to the presentation. Just by way of background, you folks, well, some of you anyway, at least two of you would probably remember in 2022, we came before this board as part of another special permit application that was ultimately granted by the ZBA for the construction of a modular construction style observation unit facility that was designed to alleviate some pressure on the emergency department. At that time, both the steering committee, which we went to again for this project, this board, and I think the ZBA said, we really need more, and I think we all nodded our heads and said, yeah, we know there are capacity issues. We sure do, and God willing, we'll be back in front of you with another project. Well, here we are. So this is a larger expansion that, again, between this and the modular facility with the observation units, hopefully alleviate some of the strain on capacity that currently exists. So if I could, I'll walk you through some slides. There we go. So again, this kind of lays out what we're going to do here tonight. I'll show you kind of how the new or renovated facility compares to the old, what the benefits are, and again, kind of, I know you read into the record the relief, but I'll dig into that a little bit. I think it's worth noting that this is an expansion, but it's also renovation. So, and you'll see it in the next slide, but the new department is going to have almost twice as much square footage as the existing department, but there's only an addition of just over 8,000 square feet. So there's a remodel taken from other areas to expand the overall size of the emergency department. So here we go. So this, I think, is a kind of helpful comparison. So the existing department is quite dated. It's over 30 years old at this point, and it's in need of an overhaul. Certainly, that's why we're here. If this petition is granted, we're forecasting completion in about 3 years, a little more than 3 years, because it'll be in the fall of 2027. As you can see, again, alluding back to the capacity issue, the current facility was designed to handle 27,000 visits a year. It's handling almost 20,000 more, 46,000 visits a year. So any of you who've had the pleasure to be in the ED recently are probably aware that there are undesirable wait times and, again, crowding, which we'll get to in a moment here. The new facility, again, when it's built out, should be able to handle 65,000 visits. So that's obviously a sizable change, and Plymouth County's growing. It's the fastest growing county in Massachusetts. I think Mark and I were speaking offline before the hearing about 5 to 7% a year in population. So there's going to be a future need, even once we kind of get ahead of the capacity as it stands right now. Again, in terms of size, I think I stole my thunder before I showed the slide here, but we're going from 14,400 square feet to 29,000 square feet and change. Again, much of that the result of renovation and reconfiguration of the interior of the building, and Mark can do an excellent job of walking you through that. We've got some slides that'll show you kind of how that all works. The number of private treatment rooms is going to increase. So right now there are 25 spaces, only 5 of which are private. We're going to have 37 private treatment rooms, and again, obviously very desirable to have a private room, if at all possible, when you're being treated. Behavioral health, that's a hot button. I think this board may be aware there was a significant proposal a couple years ago for a behavioral health hospital that was unable to go forward. I was actually engaged by the proponent due to the West Plymouth water capacity issue. And again, there was a real need for it then, there's a real need for it now. There's a shortage of behavioral health facility, and what happens is these acute behavioral health issues crowd out other types of care in the hospital. So again, is 16 rooms enough? Probably not, but it's more than the 7 that are there now. There will be an additional triage rooms, which Mark will kind of explain to you how the triage process works and how that's going to streamline the flow of patients through the emergency department. Again, we're still going to have the 2 trauma rooms, and there's going to be a real enhancement of the administrative areas and support spaces, which Mark will do a nice job of walking you through. Oops, keep going backwards. Okay, here we go. So again, we've kind of talked about it. I won't beat a dead horse. We need the capacity. Clinical staff is crowded. They're really not in a comfortable workspace as things currently stand. And again, alluding to privacy here, right now you've got, curtain bays, hallways. I mean, there's a lack of dignity, I think, some would say, in terms of how patients are handled in the hospital in the ED. Again, being stacked up like cattle in the hallways is not the way that the hospital wants to treat patients, but they're over capacity. Talked about the behavioral health issue. Again, Mark at the presentation of the steering committee mentioned that right now they don't have the space to separate male, female, adult children. And again, these folks, these behavioral health cases are, that's very desirable for obvious reasons. You've got some people with acute conditions who shouldn't be in proximity to each other, and the current facility just doesn't allow it. Again, we need a better patient experience. I think that's kind of what we've been talking about. Better patient flow, reduced wait times. Mark can kind of walk you through how that works in practice. He'll talk about how the clinical workspace is being enhanced. Privacy, again, in terms of these exam spaces, right now they're 80 to 90 square feet each. They're going to be 132 square feet in the new facility. So if I were better at math, I'd tell you that's maybe, what, a 50% increase in the size of the rooms. Most of them are going to have windows. It's going to be a much nicer patient experience. We've already talked about behavioral health, and again, just an improved experience. I'll touch briefly on the relief just for the technical element of this project, and then I'm going to turn it over to Mark, if I may. So again, as Mr. Grandy read into the record here, we've got 3 grounds for relief here, one of which I think is hopefully unnecessary, and again, we kind of touched on these when we did the last project in 2022. But the nature of this use, the fact that it's a hospital in this zone, requires a special permit. That's just the way that the zoning bylaw use table is designed. Again, it was really written with the hospital in mind, but that's necessary. So any hospital use expansion requires a special permit just by nature of the type of use. Parking spaces. So this is the one that the if required, and that's actually verbiage from inspectional services zoning determination, zoning denial. And I think the reason that it's if required, again, as you have read in the materials that were given to you, and as you can see here, we only need 170 spaces, I believe. I'm going from memory here. I think 1 per bed. We've got over 1,200. So again, we think that we have more than enough spaces, but I think out of abundance of caution, inspectional services directed us to seek a special permit for parking. Again, there will be sort of reconfiguration of the space. Mark will walk you through that, and I'm happy to speak to it as well. Really shuffling, which will be a net loss of 1 space. So picking up 8,000 square feet of emergency department, in terms of additional structure, only losing 1 parking space. So we think that's hopefully in order, and hope you agree. And again, this one I think is also more technical in nature. The existing parking spaces, some of them are undersized. They don't meet the 10 by 20 foot standard in the zoning bylaw. And again, when we reconfigure, we'd like the ability to have the new spaces align with that smaller footprint in some cases. And again, you can see that on the site plans. Okay, with that, Mark, if you want to run through the next few slides, that would be great. And you can just scroll through them with that wheel there.
Good evening, Mr. Chairman, board members. Thank you for letting us come. Again, my name is Mark Charlton. I'm the Senior Director of Facilities of the hospital. I've been there for about 14 years, and this project has been a topic for me for about 14 years to get us where we need to go. And again, we're excited about the opportunity to present that to you. Am I rolling? I'm rolling. So what you see in front of you first is parking. So on the right-hand side is Sandwich Street, and adjacent to that to the left is our existing parking lot. We call it Parking Lot B. This would be reconfigured slightly to create the turnaround, and that's where we would be rearranging a few of those handicap spaces. But we want to make that the dedicated parking lot for the emergency department. Currently, right now, most of the traffic that comes in and out of the emergency department is on the bottom of this page in a lower parking lot, so they're now having to walk across the main thoroughfare of the campus, which would we would eliminate that. The other thing that we would do is we would be straightening out main driveway that is going parallel on the bottom there. That's kind of the main thoroughfare across the campus off Sandwich Street. And right now, it's 2 lanes. It would remain 2 lanes, 1 each way, but it's got a little bit of a circle in front of it, right here in front of the existing ED, so that you have the ability to turn around. We're going to straighten that out, and then we're going to create a few parking spaces here that do not exist today, and that's where we, at the end of the day, we end up being a net 1, or I should say a -1. So this would become the parking lot for the emergency department. This would become the new arrival point. So this kind of just gives you the layout of the property there. And I'll answer any questions as we go. But what I'd like to show you next is this is the existing footprint of the hospital in that corner. The blue is all of the existing emergency department today. This small yellow or orange area is that small behavioral health space now. This pink area is existing. We converted this at the very beginning of COVID to be able to create an isolated area to manage those patients in the beginning. But we're going to be able to reuse this space as part of the ED when we make that connection. And again, I just want to highlight right over here the number of rooms or the treatment spaces. We have 50 of them, of which 16 are curtained bays and 15 are hall, and I would also say that it's more than 15 that are hall today positions, because we're really having to stack people in there with the volume that's happening right now. And again, the square footage is noted over here. So that's the existing department. I'm just going to tell you that all of this area right here is where we're going to build the new, and I'm going to show you that right now. So this is the new area. This is the new proposed. We'd be adding here, this part of the blue, that would be all new space, approximately 8,000, creating a new portal entrance, and I've got some other visuals I'll show you. A new entrance here, waiting room. People will come in. And the trend in emergency departments today and in emergency rooms is what'll happen now is you'll come, you'll check in, you'll sit down, and then you'll come and you'll get some vital signs taken, maybe some history, and you'll sit down, and then you'll finally get called into a space. We want to do the right thing, and a lot of the EODs that are happening today are doing this. They're taking a bit from Disney. Disney, you get into line and they keep you moving forward. So you don't realize that you're in a line per se, and they keep you moving forward. So our goal here is that you're coming in, you're checking in, you're immediately getting into one of the triage areas where you're getting history and vitals taken, and then we're being able to move you into a room in the space here. Again, we're changing. I'm going to jump out of here real quick. Our new total is going to be 68 rooms. 0 of those are curtained, 0 of those are hallway. So we've created private spaces, which I'm going to give you some visuals here. So what this does is continue to make a connection into the main hospital, connects us into that or the space that we built out here that was the pink that exists today, creating an internal hallway connection, and then this will all be new. Right here is our existing entryway now. So we'd build out this in Zone 1, and then we'd move over here into Zone 2 and be taking the existing space and starting to renovate it. Then we'd get into the main emergency department and renovate it, and then more here. This across the hall is currently our oncology project, our medical oncology department. That's another project that we're working with our mothership, the Beth Israel Healthcare System downtown, and we're going to be moving this off-site and increasing the size of it because it needs to be, again, not a project for here, but what it's going to do is open up this space here so that we can build out of the middle of the ED, because the ED or the behavioral unit is right here now, and create it all isolated here for the behavioral unit. This would be 16 beds all around here. We'd have some doorways in here so that we can isolate male, female, and adolescent if we need to, and then clinical space in the middle here for all the support areas and the nursing that needs to happen. So that would get us to that behavioral number of 16 there. And again, this would be the last phase that we do. As Rob said, we'd be starting this assuming we have all of our regulatory approvals in place, which include the town here, which include the state, both with the Department of Public Health and the determination in need, which we need to go through, which we're starting that. So there's really 3 regulatory pathways, all parallel, that we're working on right now. But we would anticipate that where we are, and hopefully everything going well, that we'd be able to start this section here, the new section, September of this year, and that first section being taken about a year. We would open that up and then take the next section. The next section, as Rob said, we plan to finish in the fall of 2027. Right now is where we are. I want to give you just a few visuals. This kind of some renderings that we've done. This would be the main entrance here. Again, the parking lot being over here. This is that main thoroughfare that goes down the middle of the campus right now. Parking would be on the side of that, and then again parking here. So an entryway here. And exam rooms. So private exam rooms are the biggest thing. So this is roughly 132 square feet. You know, right now we've got stations in the hallway that are curtained bays that are not much more than the stretcher itself. We can all imagine what that is. So this is a rendering of what we plan to do. We'll be doing some mock-up rooms, but kind of a clinical zone on this side for all the clinicians, a family visitor side over here, and then of course the patient in the middle of the head wall there with everything that we need to do in the way of all of the equipment. And then this kind of highlights the corridors, and what I really want to highlight here is that each of these exam rooms have got a glass sliding door on it, so that we do have that privacy we don't have today. There's nothing planned for the hallway except for a few alcoves for equipment to be here. This is an example of one of the nurses' stations. And I'll tell you right now, the clinical staff in that area are doing fabulous things and quality things that are, we're highlighted on national quality metrics and everything. The problem is they're doing it in space that is subpar, and we know that. And we really want to fix that as part of this. But this is really getting us to that point of doing all of that. And again, we've got all these private rooms. Right now, those clinicians formally have 10 spaces to sit down and do documentation and have conversations with themselves. And most of those conversations are not private because there's patients right next to you. With the new space, we're going to have it in different areas, but they're going to end up with almost 30 sit-down spaces that will have privacy. There'll be some glass elements here, and then there'll be seating behind it so that they have the ability to do all that, document, and still be able to provide the patients with some privacy and dignity that doesn't exist today. So that's our presentation. I'm just going to go back to this point right here, which is our existing plan and everything, and then open to any questions that you might have.
Okay, thank you very much for the presentation. Is anybody in the audience wishing to be heard or speak?
I support this.
There's nobody on Zoom, I know. I'll bring it to the board. Carl, please.
I really don't have any, well, I have kind of one question, is just for my own curiosity in regards to the plans. Is there also something built in when say we have another pandemic or something like that, as far as capacity and how that kind of works in regards to supplying, different needs for the community?
So the answer is yes. Obviously, we've learned from that, and there's two things. So we still have this area that we developed that we wanted to be able to isolate if we need to when we first started for COVID patients, and that's how we use that. So that's still going to be there, and if we need to, we have a door here, right here, that we can close and can isolate this off, and that would give us 11 rooms that we'd be able to do that. The other thing is, with patient rooms, both inpatient rooms and in the emergency department, we have rooms that are negative pressure so that you can manage airborne precaution issues and everything. In the current ED, we only have 2. We're going to be adding to this, and we're going to be having more rooms that have that isolation capacity for the individual, not necessarily the group. And then again, we've kind of built a small little area here just because in the middle here is our current X-ray that lives in the space. But this area here is going to be another 7 beds that if we had to, has a door down here and we could isolate that also if we needed to. So yes, we have taken that into account.
Thank you.
Okay, thank you. Ms. Keene?
Thank you, Mr. Chairman. I have a question for Mr. Hartman. What exactly are we voting on tonight? I'm sorry, Robin.
It's okay. They are requesting special permits for 3 items. special permit for the expansion of the use of a hospital, and the hospital is an allowed use in the R25, but part of the bylaw just requires them to go request a special permit for that expansion. And then the other one is for the parking. They're asking for the parking width. Right now, they have a mix of spaces that are 9-foot wide and 10-foot wide across the campus right now. The standard is 10-foot wide, but they're asking to have a mix of some more 9-foot and 10-foot wide. So those are really the two, and then they're just reducing the parking by one space, and I don't think that's an issue.
And we'll be voting on those separately or as one?
Any way you'd like. If you
Okay.
want them to be separated, we can, or we can vote on them all together if they are all the same vote.
Thank you. I have several questions for you. First, I want to thank you very much for presenting to us a plan that BI Deaconess Plymouth will actually get into today's model, or getting closer to today's model for an emergency room. I'm very familiar with your campus and your emergency room. I actually had an opportunity to spend all of last night, the whole night at Cape Cod Healthcare's emergency room with a relative. And there is such a stark difference between what they're able to provide and what you're able to provide. And I know that has a lot to do with the constraints that you have in your lot. So thank you. You absolutely meet the needs of a growing community with this project. We all know that a significant amount of compensated care goes through your emergency department, and that is obviously, no mission, no margin, or no margin, no mission, actually. That's how it goes. I'd like to know, how many times are you going on bypass with your current ED? Are you familiar with that number?
So bypass meaning diversion?
Correct.
So we do not go on diversion. We have not been on diversion with the exception of a significant power outage that had happened, and I'm going to guess it was about 2.5, 3 years ago. But we do not divert at all, and that's one of the reasons we have the capacity issues we have.
Right. That's why you have all the people in the hallway.
Yes, ma'am.
Because you've made that decision.
Yes, ma'am.
To not divert. And I know the impact. Now, I'm going to ask you specifically just about the statute that has to do with the number of parking spaces required. It is dependent on the number of inpatient beds. Is that correct? And it not on the emergency department beds.
That's the way I understand it, yes, ma'am.
Yeah. So really, this expansion, as far as parking requirements, is built on the hospital inpatient side, and the emergency department is never considered an inpatient stay
by state DPH regulations, yes, ma'am.
Yeah, and CMS, basically.
Yes, CMS also, yes.
So what I wanted to mention, though, about parking, and I think it's important for you to mention something about parking, is your behavioral health beds. And yes, Mr. D'Ambrosio, I was very sad that this did not move forward further to have the behavioral health hospital here in Plymouth. But they are really overnight and sometimes long-term beds because there's no opportunity to transfer these patients. And so in many respects, they act as if they're an inpatient bed, but they're not designated an inpatient bed. What I'm saying is that right now, parking can be difficult, and when you expand particularly your behavioral health beds to the number that you say, I'd just like you to address how you think about parking and why this big expansion, and believe me, I'm in support of your expansion, but how you think about the parking that we're going to be voting on tonight.
Well, there's a couple things about parking. I'll mention two things. We currently have our main entrance, which is where most of our outpatient settings are. That's the mailing address and the address that you would be driven to via GPS. We have a valet parking service there, and about a month ago, we expanded that to be able to have more staff there to be able to manage the cars coming in and out so that we can better manage them and make it easier for you to pull right up to the front door. We take care of your car. We're able to stack them in other lots and get more condensed parking in there. And again, that's all at no charge. And I will tell you that this is not a parking project in the way of the ED, but there are strategic conversations that have happened and are continuing to happen about what do we need to do and where should we be looking to expand parking on the campus, because we know that we need to do that as the community continues to grow, which Rob mentioned earlier. I will also say that since the pandemic has happened, the needs for the staff, the amount of staff parking has changed. There is a percentage of people now that are working either remotely or partially remotely, so that there is not that crunch all the time of capacity. So we're actually parking on any given day fewer staff cars than we used to. Now, I can't tell you that exact number. I do monitor the parking lots and I do monitor the grounds and everything, and I can tell you there are many times during the day when the farther out parking lots, which again are not on this map, but they're farther out here to the right on the campus, where there is space available. And so we're not as full as we used to be on a daily basis because of those few things that I've mentioned.
Thank you. That's all I have then. Thank you, Mr. Graney.
Thank you. And I know you work for hospitals and write stuff for hospitals, so
Yeah,
you
like 50
fully
years
understand it. Yeah, absolutely. Mr. Bolton, please.
Thank you, Mr. Chair. I actually have no questions other than a statement, which is thank you, Beth Israel, for stepping in on this project. Obviously, our emergency department systems at BID Plymouth need these upgrades. I know you need these upgrades for your staff, and the community will certainly benefit. Thank you.
Thank you, sir. Rosemarie.
I have a question. Will you be adding special handicap parking?
We're going to be rearranging some of the parking, yeah, so that there is an add. If you could go back to the second one, please. Right, so this parking lot here, we're going to be rearranging here and adding, we're going to be +1 overall on the campus for handicap parking. But we're actually, right now, those handicap spaces are across the roadway here. We're going to be bringing them into this parking lot, which again is meant to be the main parking lot for the emergency department, because the new entrance is going to be right here. So the proximity to the front door is going to improve for all of the spaces, not just the one new additional one.
Can pinpoint, is that a parking lot B?
This is parking lot B, yes, ma'am.
Okay.
Off of Sandwich Street. So there's an entrance into the parking lot right here, and then there's another entrance that'll bring you through the main way and then into the parking lot here. So you'll be able to pull through, or you'll be able to pull in, around, drop off, and be able to park. Whereas right now, you'll pull up to the emergency department, the overhang here, and in most cases, you're going down to the lower parking lot here and coming across the street, where there are no handicap spots down there. So we're bringing them all closer to the door.
Okay. And there's a section by the parking lot B, the door that is actually locked at this time. You can't enter or exit through that.
It is restricted at this time, yes, ma'am.
It's restricted.
Yes.
Inside, if you're entering, to the left, there's a section, I believe it's an overflow section.
Well, that's the one that I spoke to right here. So that entrance right now is right there, and you walk in. This right now is that space that I told you we built out. You can call it overflow, but the intent is this will become part of the ED. We are using this for inpatients right now. So this is parking lot B right out here. You're walking
Okay.
in that vestibule entrance there, and right to the left is that space you're talking about right now.
Okay.
And that currently is a 12-bed, 12 private beds, which is nice, unit that we're able to use.
Okay. That's all I have. Thank
Great,
you.
Thank you.
Okay, thank you. I have no questions, only a statement. This is something that's going to help the community. I look forward to it when it's completed. I must say I've had the unfortunate situation where I've had to go to the emergency room a few times, but I was treated fantastically, and they did a fantastic job, and I can't say enough about the staff that served me when I had my issue at the hospital. So if this is definitely going to make things better for the patients and for the entire community. So
This one keeps me up at night. I want to get it done. I want to get it done for the community. I want to get it done for the staff.
well, you've been waiting 14 years, so
Yes.
Another month wouldn't hurt, right?
I'll tell you that when I interviewed there, this was a topic in my interview, and as I was the ED, and what are we gonna do about it? It's
Right.
been that long.
Mm-hmm. Okay. Are there any other questions or comments from board members? Again, we are advisory to the Zoning Board of Appeals on this, but we will be sending an advisory report after the vote is taken by the board here this evening. Yes, Ms. Keene?
This is just, bear with me. How is the observation unit working that we approved last time?
So I will tell you, we opened that on the 14th of December, and on the 15th of December, it was full, and I'll remind you, it was 25 private beds in there. It is full, it is fabulous, the staff are enjoying it, the patients recognize that this is new space. It has taken a little bit of pressure off the emergency department, and most importantly, what it did do is this area right here, that area to the left here, on the right of the screen, that pink area that we built out at the beginning of COVID, we were using that for observation patients. All of those have moved into the new unit, so the emergency department is now able to utilize this space for non-urgent things, but because, again, there's a little bit of a disconnect right now. There's a little bit of a disconnect, so they have to step out in the hallway and go here. But they are using this about 12 hours a day right now. They didn't have that a month ago.
Right, so we made the right decision. Thank you.
Thank you.
Okay. I will entertain a motion from the board. What is the pleasure of the board?
Yeah, motion to approve. All three. We're not doing it separately.
Not doing it separately.
Right.
No.
Okay. Yeah, motion to approve.
We have a motion to approve. Do we have a second?
Second.
We have a motion and a second to recommend approval to the Zoning Board of Appeals. All in favor? Mr. Donaldson?
Yes.
Ms. Keene?
Yes.
Mr. Bolton?
Yes.
And myself, yes. Thank you very much, and good luck at the Zoning
Thank you.
Board of Appeals.
We're going to get started as fast as we can.
Okay, do we have any other business to come before the board this evening?
Yes, if I could, Mr. Chairman.
Yes, please.
I'm requesting that, consistent with Massachusetts General Law 44B, Section 5, and Plymouth Bylaw 14-1, I'm requesting a hearing for the determination of the CPC member, and I would like to request February 7th because of my schedule. I won't be here February 14th. I have to be in Chicago. And my attorney's schedule, who will need to, so it would need to be pushed back until March. Now, February 7th is an out-of-turn planning board meeting date, but I thought I would float it in front of you to see whether or not you'd like to move up to that date.
Okay, I can't guarantee February 7th. All the members are not present. Mr. David Peck isn't here, so I appreciate where we wanted. I thought we were going to have it on February 14th. This is the first I'm hearing that
Yeah,
it's
unfortunately,
being changed.
Unfortunately, I'm a healthcare proxy, and I have to be legally in
Right,
town
and we
in
want to
Chicago.
ensure that all the members are present when this happens. So we will confirm with all the members and check their schedules for February 7th. And if everybody can be there on the 7th, then, and we can get a room, Mr. Hartman, on the 7th, we'll look into it and we'll get back and we'll let you know.
Thank you.
Appreciate that. Anything else to come before the planning board this evening? If not, I'll entertain a motion to adjourn.
Motion to adjourn?
We have a motion adjourned. Do we have a second?
I'll second that.
Second.
All in favor? Mr. Bolton?
Yes.
And thank you for joining us through Zoom, sir. Ms. Keene? Adjourn your, adjourn? Yeah, you did, okay.
Yeah, I'm all for it.
Mr. Donaldson?
Yes.
And myself, yes. Thank you very much, everyone. Tonight's meeting of the planning board is now adjourned.